Good afternoon. I half think that applause is just because I'm the lucky person who drew the short stick and gets to follow Governor Romney. But I do have a story to tell, and I bet you're wondering, what does the prime number 17 have to do with gumming up the works and mass torts? If some of you are wondering, maybe that's the number of MDLs she's had. I'm unlucky twice over on this stage today because I've actually been associated with almost 25 MDLs in the 12 years that I've been in-house. A variety between securities, antitrust, personal injury, and even asbestos. But 17 does relate to MDLs, and in preparing for today, I wanted to actually go and unpack the statistics. What does our federal civil docket look like? So we've got 290,000 cases currently pending in the federal district courts, civil cases. Of that, 135,000 are caught within our 247 MDLs. So that's about 46.5% of all of our civil cases are actually pending within MDLs. I then wanted to look at it further. So I used a cutoff. I said, okay, I'm just gonna look at the MDLs that have over 1,000 claims. There are 17 MDLs which account for almost 19,000 cases. That's 41% of our civil docket is concentrated in 17 MDLs that are managed by 17 district court judges. That's a lot of power. And that is really at the heart of gumming up the works. Now, how did we get here? I mentioned I've been in-house for 12 years. When I started 12 years ago, my automatic reaction wasn't, oh, I want to oppose, you know? At that time, I think I looked at the benefits, and there are benefits to MDLs. They actually make a lot of sense when you think about the purpose, right? You look at, you don't want duplicative discovery. It's a great way to avoid it. You want consistent, or you want to avoid inconsistent rulings. And we all want to conserve our resources. You want efficiency. And so consistency, efficiency were all good, benign reasons for, frankly, sometimes defendants to actually petition for an MDL. And they still may be. But in the personal injury context, and especially I should mention, of those 17 MDLs, all but 2 involve pharmaceutical and device companies. The other 2 wouldn't surprise you are Volkswagen and still the BP oil spill. So in the world I've lived in the life sciences, this really is at the heart of what I do every day. So what happened with those really, benign purpose and valuable purpose is that somewhere along the way, Bruce Banner became the Incredible Hulk. Because the risk was always, if you create it, they will come. And boy, did they. And it starts with, when you create that MDL, where is your ultimate end game? And unfortunately, what has happened in that personal injury context, in those largest mass torts, is that the end game almost always, and certainly in the eyes of the court, has been a global settlement, an effective transfer of wealth. And what that's done is created an incentive for plaintiffs to collect and file claims, often meritless claims. With all due respect to Joe Rice, I see meritless claims every day. And in fact, if you look at these settlements, and one of the things that confounds judges today is the fact that, roughly anywhere from 30 to 40% of claimants actually get zeroed out at the end of that global settlement. The problem is we need to get them out earlier. And there's these incentives. So what is the benefit to the plaintiffs? Theirs is a volume business. They want to collect as many claims as possible, do as little work as possible, and get a settlement as quickly as possible. And really, in an MDL, the system enables it because the focus is on the company, discovery is against the company, and only on a limited basis, there's a subset of cases that you work up and you try. And then at the end of it, our judges push us to resolve it. And yes, we've enabled it too as defendants. But really, when you have 5, 6, 7, 15,000 claims, it's hard to imagine how you get out of it without a resolution. But part of it is it's chicken and egg, because the more numbers there are in the beginning and at the end, you end up with a higher settlement. And so the whole system keeps, each one pushes the other along. And we have 17 MDLs that now cover 41% of our federal civil docket. And it's not just MDLs, this happens in the state coordinated proceedings too. But I mentioned, I have some optimism because I do think there are ways that we can fill the gaps. The court's judges have been enablers in all of this, but I do see the tide changing somewhat, but we are really going to have to push. So what is it about the system and what can we do to fix it? So the first thing is multi-plaintiff complaints. And I did some math because I looked at 5 of my current MDLs, mass torts, and mass actions. And I looked to see how many multi-plaintiff complaints have we had and how much have the plaintiffs saved in filing fees, one of the reasons they do it. Another is they can defeat diversity, especially when you're in plaintiff jurisdictions like St. Louis in California. You also can join a weak plaintiff with strong plaintiffs, but you join a resident plaintiff with non-resident plaintiffs, and you've defeated diversity in those jurisdictions. And as I said, you save these filing fees. And it's ultimately the system that loses out. If you look at these are just my 5 matters that I looked at. $6.5 million is what the federal courts lost in filing fees. 10.2 is what the federal and state courts lost, and these are currently pending matters. I didn't look at historical numbers. If you look across the board, you are well into 9 figures. My guess is when you look across industry and the plague of multi-plaintiff complaints. So I really think we have to find a solution. And interestingly enough, another plaintiff jurisdiction actually disfavors multi-plaintiff complaints. So it is possible. The Philadelphia Court of Common Pleas disfavors, and actually overall, you don't see the type of multi-plaintiff complaints you see in these other ones. The other is that I mentioned that at the back end, you have 40% of claims that get zeroed out in a global settlement. The problem is we're waiting for too long to get them out. It's not that they get zeroed out, they should have never been filed. And our current process is incomplete, insufficient, and too bare bones to actually vet these cases. And we have to come up with a more standardized, because a lot of it is the lottery of who your judge is, and find a standardized process and a set of criteria that actually helps us winnow out these meritless claims. And it's incredible because if these were filed on a standalone basis, first, I don't think they would be filed if they had to do it on a standalone basis. And if they had to be, the plaintiff's lawyers would have to actually themselves ensure that these are not frivolous claims. That's what Rule 11 says. But we somehow no longer think about Rule 11. Iqbal Twombly pleading requirements all go out the window. And judges don't enforce it, nor do defendants push once we're in an MDL. So I think we also, coupled with a better vetting process in the front end, we are going to have to look at Rule 11 much more carefully. And both courts and defendants need to more selectively and strategically wield that sword. Then really we have to push the courts to think about resolution of MDLs differently. There is a tide changing. We actually at Bayer were successful earlier this year in getting an omnibus summary judgment granted in the Mirena MDL. Remarkable. We won Daubert. We showed that the law of all 50 states requires that you have expert evidence to establish medical causation. Judge Seibel agreed, and though I don't think it was her first choice, recognized that the law required her to grant an omnibus summary judgment. That's now on appeal. But that is the rare experience. And we need to push judges to consider the merits, for us to believe in the MDL system, and frankly, in any mass tort, there has to be a willingness to grant dispositive motions. Settlement is always going to be part of the arsenal, and the other is remands. Judges, it is in the complex manual. Remand is a possibility. And I think, again, MDL judges have gone into this thinking that their role is to actually bring resolution. But resolution can be remand. Resolution is not settlement alone. And then the last is interlocutory appeal, because MDLs are unique. And we have to recognize that we are concentrating a lot of power over a very large number of cases in a single judge, especially when you look at vaginal mesh, which is almost 70,000 cases and is really an MDL of MDLs. It's outrageous that you have to wait until final judgment. It's too late. And I do think we need to push and advocate for an interlocutory process that allows us, on key legal issues, seek appeal before trial. And this should be available as of right because of the uniqueness of this mechanism. And so I am an optimist, and I believe if we can make these changes and push these changes, we may again go back to thinking about the more benign and better purpose of MDLs. Thank you very much.